Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Thank you and welcome to the Jury Thinks What. This is a podcast by trial lawyers for trial lawyers. I am your host, Saul Gruber from Gruber Trial Consulting in Miami. And the purpose of this podcast is to just bring regular trial lawyers on and tell us about things that are going on and how they handle their cases. The goal is to help everybody learn something. This podcast is for both experienced trial lawyers as well as people getting ready to try their first case. We are on the Lawyer Minds program podcast, so please subscribe to both our podcast as well as all of the Lawyer Minds podcasts everywhere you get your podcast, whether it be Spotify, Apple, and any podcast service. Again, I am Saul Gruber from Gruber Trial Consulting, and we're excited about this week's guest. And this week's guest is Brendan Lupetin, an amazing trial lawyer out of Pittsburgh, Pennsylvania, who has a long history of significant verdicts. Brendan was so good that we have split his interview into two parts. One about his general thought process of trying cases, and the second, which will be the next time our podcast drops, will play the part where he specifically talks about his trial in Pennsylvania on a medical malpractice case where he got a $10.8 million verdict during the pandemic and how the pandemic affected or didn't affect him. But for now, let's look at the first part of Brendan's interview. Fascinating stuff. So welcome back to the Jury Thinks What, a podcast by trial lawyers for trial lawyers. Again, I'm Saul Gruber from Gruber Trial Consulting, and we're here on the Lawyer Minds podcast. And our guest today, I'm pretty excited about, is Brendan Lupetin from the great state of Pennsylvania, me being a Philly boy, but he's from the other side, Pittsburgh. And I first learned of Brendan in looking at his YouTube channel and The Persuasive Lawyer. I want to thank you for joining us today, Brendan.
Hey, Saul, thanks for having me, man. I'm psyched, and you're the one that watches my YouTube videos.
I am the one. Not only do I watch, but I subscribed. And
oh, you're the man.
I have to tell everybody on this listens to this podcast or watches it at any point in time, you've got to subscribe to Brendan's YouTube channel. First of all, his thumbnails are freaking hilarious. But more important than that, the stuff he talks about is exactly the things that I talk about with friends and on these programs. Just the thought process that goes in on trying cases. It's not stand up and open and be an actor. I mean, everything we do, from what tie we wear to how we ask our question to sequencing evidence, is thought out. And that's what I love about your YouTube channel. It makes everybody think.
No, thanks, man. And I love it. I love trial. I love trial theory and strategy. I love the psychology about it. I just think it's so fascinating to, I don't know, just learn these kind of peculiar ways that the human mind works with decision making and just the, way impressions impact, the way people think and act. It's just, the stuff that I think we learn in trying to convey a message and talk with juries is so applicable across life. I think a lot of it makes me a better person, because so much of it is, looking at life through the point of view of somebody else, so you have to look at your case through the point of view of the jurors, just like whenever you're dealing with anybody in business and, your personal life, always trying to see things from their perspective, I think just is going to increase your empathy to understand the process of it all. But yeah, I mean, in the end, you and I and a lot of other trial lawyers are just kind of nerds about it. It's just that passion, that calling to deep dive into all of it.
One of the interesting things about the pandemic I've seen is, although I've been reading the books, whether it be watching and listening to the Mo Levine tapes that I got 15 years ago, to the Reptile, to everything that's happening today, now we had a breath, and we were able to actually sit down and not have to worry about doing a deposition necessarily for a few months and just read and think, which is really changed a lot of the way I do things. I'm not trying cases anymore now, I'm consulting, but it's changed the way I think of everything now because of the pandemic.
Yeah, although it's like the pandemic, with people having more downtime and being more in front of the screen and making seminars more accessible. I mean, I would say in the last 10 years, this massive pipeline of great trial strategy information came out, through the trial guide books and different seminars, Reptile, Trial by Human,
right?
Friedman Malone, Mitnick, all these wonderful people doing all this great stuff. And then the pandemic hits. And while it's awesome for junkies like us, I mean, it was literally like the fire hydrant was like cracked open.
Yeah.
And there is so much information now. I can't even keep up with it. I literally have to figure okay, am I going to do, follow, trial school, or am I going to do the TBI seminars? I'm going to do the Dan Ambrose. It's like, you can't keep up with all of it.
You really can't. And
it's a blessing and a curse.
One of the things I've done, because I definitely follow Dan Ambrose because I've been friends with him for a long time, just from my AHA days. But I now look at, instead of the people, I look at what the topics are they going to cover. And is that something I want to know more about? My biggest problem, and I'm wondering if you have the same problem, is I want to follow all the topics, and it's become problematic.
Yeah, I mean, who has time for that? Even if, our practices have become more efficient with doing everything via Zoom or electronically, or you're just not doing as much stuff because of all the pandemic issues. Still, I mean, I cannot find time to keep up with all of it. So on a related note, so we have really crummy voir dire in Pennsylvania, at least on this side of the state. And we're a weird state because it's county by county rules, but pretty much all the counties, Allegheny and surrounding, it's just very, very limited voir dire. And voir dire is incredibly important, and so many of these different seminars and all these shows and everything out there focus so much on voir dire. So that's one that I mostly just skip over those because it doesn't apply to my practice all that much.
I've always done the same thing because my practice was mainly in New Jersey, and it's all judge-driven voir dire. But we convinced the Supreme Court about 7 or 8 years ago to give us three open-ended questions that judges still hated. So I always avoided it. But I kind of, once I read Keith Mitnick's book, to be honest with you, it piqued my curiosity a little bit more. And I started to say, well, maybe we can use some of those issues in opening statements, the way he phrased certain things, to kind of start talking to the jury in openings about some of the stuff he does with burden of proof and pies and things like that. We could start doing. But you're right. So let me go back a little bit. You are a trial lawyer in Pittsburgh. How did you get involved with that?
So you hear these stories sometimes about these wonderkin type trial lawyers, and they come out and they're whacking 7-figure verdicts on their first try. I was anything but that. I was kind of the disillusioned law school student. I didn't know what I wanted to do. I mean, I thought about dropping out of law school at one point, and I had pretty mediocre grades, and kind of just fell butt backwards into a personal injury firm in Pittsburgh, and really had no idea what I was doing. And even for the first 8 or 9 months, was not really into it. I wasn't, doing complaints and preliminary objections and summary judgments, and maybe, deposition summaries weren't connecting with me. But then, because it was kind of a Wild West type firm, I was told one day, 9 months into practice, you're going to go try this case next week. and it was a medical malpractice case. And
Wow.
yeah, I mean, it was not a very good case, as you could imagine, is why the low man on the totem pole was given it. So no idea what I was doing, but I got into it, and I just immediately was like, this is awesome. And we lost instantaneously. I think we didn't even, my client and I didn't even get out of the courthouse before we got a call that the jury was back. And so, but I was really hooked at that point, but still had no clue, like, what do you do with this? And so I was like, I'd search Google, like, how do you do an opening statement, and how do you ask questions, like the most rudimentary stuff. And that was 15 years ago. And there really was not very much information out at that time. So I tried several more cases and pretty much lost all my cases at first. And they were not very good cases. Although some of them now, I think I probably could have won now. But, just learned and learned and learned from every one of those, then eventually stumbled onto these different trial books. I think like the first one I read was David Ball on damages, whichever version was out there.
I had a feeling that was the first I read.
Yeah. And then, found my way into the reptile and, became just obsessed with reptile and now edge for a really long time. And then I discovered trial guides, and I discovered these seminars around the country, not just the local seminars that are done in my area, and really broadened my horizons and started to read about other trial lawyers, which I always find the most like motivating and inspiring, that, this person accomplished this incredible thing. And then they're real. Like, I saw them at a seminar, I saw them talk. It's a real person. And it's like, so it can be done, like these are mortals. And just got really hooked on it, and then really just grew to love the psychology of everything. And, it just goes on and on and on. I just love it so much, and continuing to try to just immerse myself and learn more.
And I know there's always this dichotomy of practicing law. There's the business of law, and then there's the practice of law. I've always dedicated myself to the practice of law. Was never good at the business of law. And I see a lot of people out there are very much concentrating on the business of law. We see a lot of new lawyers that are coming out, hanging their own shingle. And they're not necessarily getting that involved in the practice of law. And I really think they're doing themselves a disservice by not figuring some of these things out. So some of the things out that you were talking about. I'm looking at your verdict sheet. I got this from your webpage. We're going to talk about the $10 million verdict that you just got during this pandemic in a minute. But we're looking at $1.7 million in a bad faith case, $2 million in a gallbladder case, 2.1 in a slip and fall against Target, 6.3 brand marketing versus Intertech. So you're really using what you're talking about, and you're not just talking the talk, you're walking the walk, as they say.
No, 100%. I literally write goals down every year, and I put them under the glass under my desk, so I have to see them every day. And there are, a lot of different things I want to accomplish, but always I put in, try at least 3 cases to jury verdict this year. That's my goal every year, is a minimum of 3 cases to verdict. And I'm 15 years in. I've tried about 40 cases to jury verdict at this point. The first 10 to 12 to maybe even 15 were mostly losses or really pathetic verdicts. And then I started to get some, moderate success, getting some okay verdicts here and there. And then it was that brand verdict case, that one that we hit for 6.7, 5 million of which was punitive damages, that really opened my eyes. Because before that, I don't think I'd ever even had a verdict of more than 6 figures. And it's sort of like, it still doesn't seem real at that point. It's not like until you actually get a substantial verdict that you realize what's possible. And I don't know, there's something about that. Like, it happens, and then you realize, like, whoa, this can happen. It really can. And these juries that you're bringing in there, this group of people, they can do whatever they want. It's a wild situation in that sense. Like, this group of people, they have all this power. And that's actually something I always try to stress with jurors throughout it is that, not just the importance of the case, but that, this is a rare opportunity. And to get them to see this rare opportunity that they have, to hopefully stand up for my client, is the number one thing. I talk, and I did that in this closing was, because I think we all do it. Okay. We all try to think about, where do we have commonalities? And I always find myself, if I see the news and I see some story about some unbelievably heroic act that somebody did, a bystander sees somebody trapped in a car and they risk their life in a burning car to pull that person out, or what you name the heroic circumstance, and you are always left thinking, my gosh, like, will A, I ever be put in a situation like that, and B, how would I act in it? And maybe in your life you'll never be put in that situation. And I try to say that, and you just ask yourself, what would I do in that situation? I'd like to think I would do the right thing. And then I talk to the jury and I say, this is your opportunity. This is that moment in your life to do something really important. And you have unlimited power to stand up for this person over here, to help them, in this moment of need kind of thing.
So it sounds like you're putting the jury you're putting the jury in a hero position. You're saying you have that ability here. You are the hero.
Carl Bettinger, right?
Yeah.
12 heroes, one voice. I think that analogy.
And remember, Carl was a nursing home lawyer.
I know. That was a nursing home case that he wrote.
It was the Manor Care case.
Yeah.
We know it well.
Yeah. So I think it's just an amazing process. And, but I think I got sort of sidetracked on the importance, for me as a young lawyer. It's like I struggled. I loved it. So it was a pleasant struggle, and I lost repeatedly, and it's never fun to lose. And in some cases, it was particularly brutal and so hard to deal with. But it's like, if you keep going and you finally push through and you see kind of the other side. Okay. So like the first time I hit a really substantial verdict, it was like, I'm sort of embarrassed about this, but I'm not, because it was the way I felt. When the jury came in and read the verdict, like the first number they read was, many, many, many times bigger than any number I've ever gotten a verdict. I literally started bawling, crying. And I wasn't doing that like contrived. I was so overwhelmed with emotions thinking about the fact that it's possible, like all this hard work, all these years of doing this, it finally happened. And in a particularly important case for the client I was representing, I couldn't hold it back. And it's like, if you just don't give up, eventually you'll see that. And then once you see that other side of it, like you kind of push through, what is the Jim Morrison break on through the other side?
Right.
It just changes your whole perspective, and you realize what's possible. And then for me, that just further just sparked me. And I've really have had, I've been on a good run since that case. I mean,
you want more once you get a taste of it, is what you're telling us.
Yeah. But it's that idea of it showing you that it's literally possible. Like for me, it started with seeing people that had gotten these big verdicts in person. Like, I don't know, that might just be particular to me. But, and knowing, okay, that person, I talked with them for a second, and that person has this list of these unbelievable trial outcomes. Okay, so that's a real person, it's possible. But it's not until you do it yourself that then you're like, wow, it can be done. And I really can stick up for my clients, and I really can be tough in my mediations and my settlement proposals on behalf of my client, because I know now that it is possible. I've done it before. And I think it makes you a better advocate, better fighter, etc.
One thing I realized probably 10 or 15 years in is the trial, at least for me, can't be about the money or the legal fee that I'm going to get. It has to be about something so much more. If in the back of my head, I'm thinking, well, I can get a 6-figure verdict here, I'm probably not going to get a 6-figure verdict here.
Oh,
if I think in the back of my head, I may really help this person. I may convince 8 people that not only is my client right, but she's deserving, and
right.
They can help her. And that's when the verdicts start to come.
I probably try a lot of cases because of the fact, I don't know why, I'm just wired that the money is never a huge consideration for me at all. And it's not really real until it's done, and I can tell my clients, I was like, look, you have to imagine it's a briefcase of money on the table, but you do whatever you want. Okay. I never, ever push my clients to take a settlement unless it is just absolutely in their best interest, and they would be making a drastic mistake. But, if it's I don't know, I think that if they really believe in their case and they want to go try this case, I'm going to let them go try the case. But I'm not ever thinking about the money at trial. I'm thinking about, one of the things I'm thinking about is how much in most instances, by the time I get to trial, even if we've had our differences, how much I love my client. Okay. Their quirkiness, or sometimes you just totally resonate and you just always love them. Other times you have the client and they maybe drive you crazy at times or whatnot. But then the two of you are going through this peculiar experience together. You can't help but, develop that bond. And then it's like, I don't know about you, Saul, but I think most trial lawyers, okay, especially if you stick with it, you have to be a pretty competitive person.
Yeah.
Okay. And it's like, you get into there and I'm like, this is my client. This is my team. We're going to win. We got to find a way to win. I got to win for my team, and so that's what I'm thinking about. I'm thinking about how can I use all this cool stuff we learn, and apply it into this case. But to your point, if you ever went to try a case and you're thinking about how much money you're going to make, it's like never even crossed my mind.
Right.
When I'm trying a case, like never.
It can't. I mean, it's like counting strokes. I don't know if you're a golfer, but it's like you're having the best round of your life and you're on the 14th hole and you're counting strokes. You're saying, wow, I may shoot. If you say that to yourself, you're going to, triple bogey every single hole for the rest of the round.
Yeah. I think I just am so fascinated with all the other parts of it. I'm interested in what random group of people do I get out there? I always think about, maybe a week before your trial starts, we do 12-person juries here in Pennsylvania. And I'm always like, there's 12 people somewhere in Allegheny County that don't know it yet, but in a week, they're going to be having me talk to them and all this different stuff. And I just find that so interesting and cool. And then you get in there and you're trying to figure out, I don't know, how this is coming across to those people, and then focus groups and all that stuff. It's so.
And that's one of the things I hated about New Jersey and our lack of voir dire was I felt like my ability to connect has been stripped to a certain extent where I could just talk to the jurors, not ask certain questions based on evidence that the jurors are going to listen to, but look at their eyes and say, hey, what do you think?
Yeah.
And I hear about this voir dire that people have all over the country, and it's fascinating.
It's mind-blowing.
It really is. So let me talk to you about, you just received a huge verdict during the pandemic for a medical malpractice case, correct?
Yeah.
Why don't you tell us a little bit of the background of that case?
So it was a medical malpractice case, and it was in Blair County, Pennsylvania, which is about 2 hours east of Pittsburgh. So Pittsburgh's the western side of Pennsylvania, and it's a very rural county, a very red county. For example, we had our associate go out and review juror questionnaires that were available to be reviewed several days ahead. And he was looking at the people and then looking at their political affiliation. And he's like, I'm just not going to do this anymore because 98% of them are Republicans. I'm like, yeah, but we don't even need that issue at this point.
So that's interesting. So you actually have the ability to look at the panel prior to getting to court the first day of picking the jury.
Only in this county, and they don't have that in Pittsburgh. We're Allegheny County, and you cannot do that. That's not available. But we had found out, in lead up to trial from the judge that the juror questionnaires are available ahead of time. So we want, you always want as much information as you can.
Absolutely.
Yeah. So we had our and by the way, I tried the case with my partner Greg Unatin, who at this point I cannot try a case without him. You know what I mean?
I do.
Yeah. I mean, but this case was interesting because, Greg and I have been trying cases together for a while, and a lot of times we're going all right, well, what do you want to do and what do you want to do? But this trial really crystallized for me, know your role and know what you're good at. And there are certain parts of the case, for instance, I don't know if I don't have a penchant for it. I don't enjoy it that much doing direct exams generally, but also in particular directs of our experts. On the other hand, the smoothest, best direct exams of experts I've ever seen are my partner, Greg Unatin. And we had it set up that I, by chance, was going to do the direct of one of our experts. And I started getting like anxiety the night before. I was just like, oh man, like I'm not connecting with this expert. He's not hearing me, etc. And I called Greg and I was like, hey man, can I take the one doctor on Cross, because I love Cross,
Right.
And can you do the direct? And he was more than happy to. And it was the best decision because he was so good.
It's so funny you say that, because I've said to people for years, direct examination is a really important skill that a lot of trial lawyers don't even think about.
So important.
And I also find that people who are very good at cross-examination may not be so great at direct, because in direct, really, we're the stars, the expert. We're just there guiding them. Cross,
you're the star.
We're the star. So I think that has a lot to do with it. But I've botched directs of experts. And it got to the point where I stopped doing directs of experts. I also had a lawyer, her name is Victoria Shaw. She's still practicing in New Jersey, who was I don't want to say my second, because that's so demeaning. She was my trial partner. And we just started to figure out which one of us was good at different things. And 100%. She did all the nurses. And because I'm just bad at it.
Yeah. And, I started out and I tried so many cases entirely by myself. And so I just got used to that. And so when Greg and I first started trying cases, it was just, I had a hard time letting go of certain parts of the trial. But as he and I tried more and more cases, it's just like, it would be bad for the case if I tried to do the parts that he's so good at. You know what I mean? And I'm so thankful for that it's developed into that. But
I'm going to have you back on, because we could talk for about 10 hours about all the things we're talking about.
I tell that to my wife. I'm like, I could literally, when I get on, if I do this kind of stuff, it's like, I could just go and go and go and talk forever about it. I don't have that really capability in any other part of my life, but when it's trial stuff, forget about it.
But one thing that I think is important, we've given some younger lawyers a lot of things to read, and I think they're probably reading it already. I don't care how many books you read and how many times you read them. Unless you're in there trying cases, it's all nothing.
100%.
Yeah. And one of the things, and then I want to get back to the pandemic issue in your trial, but one of the things that I've always done, I have about 3 books that I highlight. One was David Ball, the other was Rules of the Road, and now it's Keith Mitnick's book too. And before I tried anything, when I was starting to think about it, I would reread all my highlights.
Yeah.
Just to kind of say, oh, you know what, that may work in this case. That may make sense in this case.
Correct.
I would definitely recommend people do that.
I think it's also helpful to so I have two pieces here, related note. One is, for me, I read all the other books all the time and I'm constantly going back to them and everything. But I find personally my sort of trial Bible that I go back to always to get in the right mind state is On Becoming a Trial Lawyer by Friedman. As far as an overarching way to think about trying a case as a lawyer, I don't think there's any other better book. There's tons of, it's not a technical book. Okay.
Right.
It's a belief system. It's how to think. It's how to just feel the process that you're wading into. And that book, there's no better book for me to get me in the right mind state. Now, the other thing, because it is harder and harder and harder to try cases, what I find tremendously helpful in those months of time, sometimes almost a year at times between trying cases, is Courtroom Viewing Network and watching good lawyers actually do it, because you're getting that feeling of what it's like to be in the courtroom, which is a completely, the seminars don't do it. Books don't do it. It's that feeling. It's the juror coughing, or the dead silence, or the awkward pauses, or the things. Watching those actual trials, I think, is critically important in those periods of time when you're not trying cases, to stay fresh and to get that part of your mind remembering what it's like to be in that courtroom.
I have an interesting question for you. One of the things we always, every one of my clients and me as well, when I was trying cases, is that you would be so afraid of looking like an idiot and so afraid of what if this doesn't work? What if I stumble? What if the something else doesn't work? And then I began to realize that that's called being a human being.
Mm-hmm.
And it's going to happen in every trial. And if we embrace it, the jury may like us even more. How do you feel about that?
I think that number one is one of the reasons I love trials is because inevitably you will do something stupid, you'll fall on your face, something won't
Sure.
work out the right way, and you'll have some egg on your face. And I personally, I love having stories to tell people, you know what I mean? Just outside, like at dinner or something. And there's no, for me, better, place for stories to generate than trial. But I use that as a mindset, so instead of fearing, well, what if I screw this up? And what if I screw that up? Then my thought process is worst case scenario, I'm going to have a great story to tell. So that's one way that I think about it. But number two is, as long as, you're not being a bully or a jerk, or again, somebody not you, even if you screw up, it might help you in a sense, because again, it humanizes you and the jury sees that you're not perfect. And as long as you acknowledge it and you say, you know what, that was a bad question. Or even in closing sometimes, like maybe you got carried away with a witness or something, I'll apologize to them, hey, nurse so-and-so, I mean this. I got carried away and I lost my temper, I lost my cool, and that is not cool. And I'm sorry. And ladies and gentlemen, I just asked that you hold that against me and what you think about me. Please don't hold that against my client. But
you have to acknowledge it. I mean, you have to look them and acknowledge it.
If you were jerky and to you it felt like it wasn't you. Now there are people, I think, who are authentically a-holes.
Right.
That's just who they are. And the jury gets that, and they can do things, again, getting back to some people can do things and some people can't. Me, I have this dying hope that people like me. And I want to be a nice person and a good person as much as I can. I just want to please people. And so I get fired up in trials sometimes, and I am overbearing and jerky. And it's immediately apparent. And that's one of those things that you have to tell yourself, like, don't do that. Like, there's no upside to being a jerk or being nasty, at least for me.
We used to have, because we always tried cases together. I learned early in my career, it's always good to have a second set of eyes. It's also always good to have a second set of hands as well, but it's always good to have a second set of eyes, because as you're bearing down on crossing their main expert, I want someone watching the jury to see how they're reacting. And we would have little laminated cards printed up that we would have for every trial, that it would be flashed to me, or I would flash it to the person I'm trying the case with. Sit down.
Ooh,
stop.
I like that idea.
No, end. Where you think you have to keep going, and right, because when we were in law school, it was the Irving Younger tapes we listened to, and he used to say, you only have to ask 2 questions on cross, but will you? No, you won't.
Right, exactly.
So they're great, and
I like that idea of the cards, because inevitably it's usually Greg writing to me like, take it easy, or
exactly,
slow down.
So if you have them, it's perfect.
I like that.
And you just don't want the jury to see them, obviously. But that's easy to do. But that's
better than Greg writing a note on a pad and like trying to get my attention with it. Like, look at this.
So again, we are both geeking out, but that's okay. That's what we do for a living. Again, we're talking to Brendan Lupetin, trial lawyer out of Pittsburgh. This is Saul Gruber Trial Consulting on The Jury Thinks What. That's the end of part 1 of my interview with Brendan. He was so informative and so engaging, we decided to separate these into 2 parts. But we learned a lot from Brendan today, from what books it would be a good idea to read, to some advice to all lawyers, which is you can't think about the money or the value of the case once you're in the trial. Once you're in the trial, all you can think about is the trial and the plaintiff. And that's wise words from a really wise lawyer. Something that I thought was pretty interesting from Brendan is the way he utilizes rules in trial and the way he uses the second question, such as it's up to you if someone injures another needlessly, if they're responsible for the harm they cause, and let me tell you what happens. Something along those lines, which I think is very valuable in a case. So look for our next podcast where we'll continue our conversation with Brendan. And in the next podcast, he talks much more regarding his recent $10.8 million verdict during this pandemic era in a medical malpractice case. So thank you, Brendan. We are now at the point of the podcast where we go and talk about our nursing home minute. And at this point, we want to talk about the depositions that you must have. In a case we are working on in out west, the plaintiff lawyer lost the arbitration argument, and we're now in front of an arbitrator. And in that case, he only gets 3 depositions. So in talking to him last week, we were discussing who we wanted to depose. We agreed that without question, we need to depose the administrator and the director of nursing. Normally, I would add either the medical director and the MDS coordinator as the must depose people. We always want to depose those 4 people. But in this case, where you're limited to 3, we decided to just do the administrator and the director of nursing and save the last deposition to see what happens in those first 2 depositions. So there are ways to handle these cases without taking 20 depositions. Our rule of thumb is you always want to do, at the very least, the administrator, the director of nursing, and the MDS coordinator. Certain times you want to add the medical director, and then you can get to the other people, other caregivers. But in this case, where you're extremely limited, we went just with the administrator as well as the director of nursing. And, as you know from all of our podcasts, we try to give a quote, a song title, something that perhaps you could use at trial. And one of the things that we notice in virtually every case, and certainly a lot in medical malpractice cases and nursing home cases, are communication and the lack of communication. And there's a really great quote that I've used a lot of times by George Bernard Shaw, which goes something like, the single biggest problem in communication is the illusion that it has taken place. Think about that when you're trying cases and communication is the issue. Once again, this is Saul Gruber from Gruber Trial Consulting, and thank you for watching and listening to The Jury Thinks What on the Lawyer Minds Podcast Network.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.